alleging where in UAE in 2018, the Federal Arbitration Act, where Section 20, Article 28, 33, and 35 put the things like you don't require any physical presence in the international commercial arbitration. So anywhere the counsel can be, or the arbitrator, or the witnesses. Taking that high, compare with Bangladesh, how could we minimize that gap? What to be done?
Well, I think Anil just said a little while ago that there has to be an interaction by the government. Because government has to be a big player in it, because it's a big stakeholder, because you're dealing with the legal system effectively. So when you're dealing with the legal system, the government has to be a real stakeholder and play a part. In the Middle East, that's what the government has done. They have been pretty laid back, but then they have got their new law together. So, and they've done a lot of discussions with a lot of people. Okay, so both internally and externally, and Dubai is, in fact, Dubai is now working towards becoming a hub. Indeed, I have an arbitration. Absolutely, they're investing quite a lot. And next week, I have an arbitration in Dubai. So it is going to become, again, hopefully, an arbitration-friendly environment. And that should be the direction that we should have. So not only should the business community take a lead, but the government should be involved, and the government should make way for laws which will make arbitration popular in this country and reliable. And whoever uses arbitration, the consumers of arbitration services should be comfortable that they will be getting justice at the end of the day. Thank you. Absolutely. Absolutely.
If I could just add on to that, if you look at Dubai, you'll understand that Dubai's idea is to make both the seat of arbitration and the venue of arbitration for the Middle East, right? All of the Middle East. So the question that you have to ask is this: are you looking at Bangladesh as the venue for your arbitration, or as the seat of arbitration as well, right? And to do that, think about it. You can reach out to India, you can reach out to Myanmar, you can reach out to possibly Thailand and all that. So as a venue for arbitration, you do have an opportunity here, right? But to get to that venue stage, you want to also consider whether or not these countries will look at Bangladesh as the seat of arbitration. To do that, we come back to the same thing down the line from the government, from the judiciary. From what I hear from the justices, what they spoke about, it looks like the court system is in good hands, right? You're doing the right thing, you're taking the right steps, you're making the right decisions. So the question then is, on the left hand, what are the government doing for that? On the right hand, what are practitioners doing? What are the institutions doing? Right? So if you put all of these into place together, you can replicate the regulations that you spoke about, right? Now there's a slight angle to that as well. Remember I mentioned to you appropriate dispute resolution. A large portion or large interest of mine is online dispute resolution, right? And this December I'll have my second article on online dispute resolution in the Asian Journal of Mediations coming out. Now there's this big thing that's taking place about online dispute resolution. I sat as a mediator in an online dispute resolution where the parties were never physically with me, but we video conference. So some of those things can also work, right? It's just a matter of setting the framework. In June this year, I went to Osaka for the Asia Pacific Economic Cooperation framework on online dispute resolution platform and protocol. So we are putting things in place. So if you want to move up, you may want to think about technology-based progress and then up. So you could be a front runner dealing with that. When I spoke about online dispute resolution in India, they said they're not up there yet. So you could take a step forward, implement that along with everything else that you're thinking about in terms of arbitration, and possibly look at alternate dispute resolutions as well, and move forward.
I mean, if I may, I just wanted to say that for this, you need to create awareness among the people as well. And you need proper training and institutionalized training for the arbitrators as well. I mean, anybody, it's not that the judges can be the arbitrators, as the presenter, Dr. Khalid Chaudhary, has already mentioned. So for this, we need to create awareness among the people and institutionalize, as we say, proper training and whatever. Is that correct, sir?
I agree with you, and I'd just like to highlight two things.
Yes.
I know 4 Bangladeshi gentlemen very well over the last 6-7 years. They're all here.
I'm sure.
Right?
Yeah.
And today I've just had the experience of finding out what the judiciary does. I must share as a Singaporean, I think you guys have an incredible potential. You guys are almost on par with any other countries in terms of your knowledge and experience as lawyers, and experience as judges. QC, you have a QC here as well, right? And I think you should not look at yourselves as a third world country. You need to just tell we are on par. We can get into the system. We've got a judiciary that's supporting us. We just need institutions and proper training of the arbitrators. And let's move it all. And it's all, do it all parallel. At the same time, like when some of the older countries like Singapore may have done it step by step, you have the opportunity to run everything parallel, right? And the training is very, very important.
May I move on to Mr. Justice Sharma? Just asking in a domestic perspective, do we require any dedicated bench, especially for the section 42 to 48, where require the set aside and the enforcement, and also for the section 12 for the appointment of arbitrators, because which related with the domestic arbitration, going to the district court and takes ages, and also the 7A. So my question to you, do we really need a dedicated high court bench for that?
It is for the convenience of the lawyers that you, the lawyers, are demanding that High Court should be the forum for international commercial dispute for appointment of arbitrators. But I don't find anything wrong in having forum at district level. So currently, the international commercial dispute for international commercial dispute resolution, the law says that you will approach the High Court. So the only objection, the only issues you are taking always before the court, that the executing court. That you are obtaining an award from Singapore, from a foreign country, but as per the present law, you need to go to the district court. The people, the barristers do not want to go to the old city. That's what my opinion is. Otherwise, there is no problem. There may be some other reason. But you should approach the legislature. And first of all, you should approach the Honorable Law Minister. And of course, you should keep writing in newspapers about the advantage and disadvantage of making this forum in the district court level. Since the High Court Division is well equipped, capable to deal with the execution matters, presently Admiralty decrees are being executed by the High Court Division. So of course you can do it. But you need to approach to the proper and competent authority. By making all this discussion here, I think you are not going to get any result. So you need to approach, first of all, the Law Minister. Then, of course, you can share this issue with some member of Parliament as well.
If I could add, we don't have a specific bench that deals with arbitration. What we had was maybe about 10 years ago, they assigned the arbitration cases to a particular judge or two, right?
We have it there too.
Yes. And once you do that for about 4 or 5 years, and they set the platform and ground rules, then it can spread on to the rest of the judges, not a problem. But to get a consistency, if you narrow it down to 2 or 3 judges at the most, right, that deals with arbitration matters, you get that system in place. You get the consistency, you get the decisions that are international in nature, the approach that they take, and then moving on to the other judges, you can do that. You can do that. That's the take from Singapore. We have the same for construction as well.
Just can I pose one more question as well?
Right.
Like in international commercial arbitration, the addendums, generally, the tribunal doesn't accept without valid or strong reasons, and they impose very high costs.
Right.
Where in our like ad hoc arbitration practice in Bangladesh, we don't see much on that. But another thing is if you see the ICC arbitration rules, Article 23, where the terms of reference and putting the limitations. Can we start that practice in Bangladesh as well, that putting in a strict time limit with the adjournment imposing costs and the terms of reference initial speech?
Exactly. Absolutely.
Provision in the law.
The example I would want to give you is the very first fast-track arbitration is taking place in BIAC, and I'm the arbitrator. Okay, the difficulty that I have, we were supposed to finish it in 3 months. Okay, so 3 months from the date of the appointment of the arbitrator. So 2 days after the appointment, I had a meeting with all the parties, and then get procedural directions, and we decided that we would finish the case within the 90-day period, and gave directions. But then what happened? One of the parties fell ill, or the managing director fell ill, and he says, I'm in India. Don't know whether he's in India or not. He's undergoing treatment. His lawyer says, I haven't got any instructions. So as an arbitrator, I'm in a difficulty as to fairness. What do I do here? So I keep on asking the lady at BIAC to write to him to find out when is he coming back. And I can't give directions for the next hearing. And also what has happened is they've not complied with some of the rules by making the payment, etc. As you know, obviously when you have an institutional arbitration, you have to pay the institution the money. He is not. So on that basis, effectively, he's debarred from running his counterclaim. But nevertheless, when you have a dispute resolution process which is hostile, and you totally exclude the other party, to me, it doesn't sound fair. I'm sure the judges that are here, they also would share the same feeling. So, exactly, and it's not rational either. So if someone else is looking at it, on either a review, that they set aside provisions, or there isn't an appeal here. So when someone else is looking at it, they say, well, was that really fair for Mr. Hussain to set the time limit? And this man is saying, I'm having a heart attack or whatever. I've had a bypass surgery, haven't quite recovered, and Mr. Hussain wants to hear. So at the end of the day, it's going to be difficult. So that is the real problem that we face on adjournments. But the point that I was making about whether the international commercial arbitration should be dealt with and enforced in the High Court, there is a point, because in the district court, the judges aren't experienced enough, and we don't have, and it's like in the sub-courts, in the subordinate courts in Singapore, the judges aren't experienced enough, so but the judges in the High Court are. So that is one reason why you want this international arbitration matters should be dealt with solely in the High Court, The other reason is that if you start in the High Court, then you've excluded one layer, right? So you've excluded one appeal.
If you order
Absolutely. That is the real problem. Exactly. That's one of the curses in our system, unfortunately.
If I could add on that, right? The first arbitration I had 18 years ago was an ad hoc arbitration. But the arbitrator said with the parties, it decided that we will follow the rules of court. And with the rules of court, there are strict timelines and there are default positions. So it was fine because parties agreed to that. So I can appreciate where you'd have a problem with the situation that you have, where there are no rules in place. In fact, in the coal mine arbitration I described, it was under the Singapore International Arbitration Act, and it had its own arbitration, Singapore International Arbitration Center, and they had their own rules. But yet I was kind of defaulting and slowing down. But they had a problem finding the arbitrator on. So you have those complications. But the idea is, I think as far as possible, you must have institutionalized arbitration, point number one. Point number two, if you are going to go down the path of ad hoc arbitration, you really need to set the rules that parties agree to. Now, taking on QC's point, someone once in India mentioned this, that with a court you get justice, and with arbitration you get natural justice. So there is that issue about making sure that there is some form of natural justice when you deal with the parties. So if you don't have rules, you deciding and imposing that may not be fair to the parties. But if there are a set of rules, you just turn to the set of rules and you tell them, you guys chose the set of rules, please follow. All right?
Madam Justice. Just as we do the ad hoc arbitration, what we see, like mostly they follow the Civil Procedure Code and the Evidence Act.